Hello, I'm Stephanie Price, Communications Director here at the Black Farmers Agriculturists Association in Memphis, Tennessee. I'm sitting here with Thomas Burrell, President of the Black Farmers Agriculturists Association, asking him questions pertaining to this video. Mr. Burrell, how are you?
I'm quite fine, ma'am. Thank you for asking.
Great. Ms. Burrell, what is the main topic of discussion in this video?
Well, this video is a result of several other videos that we have produced and have on our website. And we want our members to also go to our website and do two things in particular. We want them to update their website address, and we want them to call the office to make sure that we have their current mailing address. We believe that there is what we would refer to as traffic regarding some of the motions that we have filed in court, and that we believe the court, or the courts rather, because we have motions in more than one, are about to make some decisions regarding some of these motions. And we want, first and foremost, our database to be as accurate as possible, because there could be a possibility that because BIFA is in fact a plaintiff in these lawsuits, we instituted these lawsuits, it may be incumbent upon us as opposed to the defendant, USDA, who has otherwise been liable for or responsible for getting the notices out regarding any final order from these particular judges. So if in the event that the judge should rule that in our favor and that we will be responsible for notifying our members, we want to make sure that our database is as accurate as possible, because we know that in the last year, 2 or 3, individuals may have passed on, they may have moved, etc., and we want their heirs, their assigns, and or administrators to make sure that they receive these notices.
Mr. Burrell, you mentioned the status of certain lawsuits. People are either asking and or stating that the lawsuits are closed. What's your response to those statements?
Well, our response has been, even as early as 2013, we told people then, we acknowledged that indeed the lawsuits were quote unquote closed. However, and there is a however, a lot of folk will call and say, well, we heard that it was closed, and we saw on the web page where it was closed that somebody from a law firm said indeed it was closed. We acknowledge that. However, there's a difference between a lawsuit being closed on the one hand and your ability to continue to create activity, that is to say, file motions, responses in those lawsuits after they're closed. And sometimes I will give an analogy when I'm holding a meeting to help to explain that process. One analogy that I would give is if you are at your bank on Friday afternoon, the bank otherwise closed at 5 o'clock, and you get there at 4:59. You're inside the bank. There are 10 other customers in front of you. There are customers sitting down at other desks at loan offices taking care of business, as it were. Somebody from around the counter is going to come and lock that door at about 4:59, or at least by 5 o'clock if the bank is closing at 5. But when they close the door, they don't put the people inside out. They prevent people on the outside from coming, quote unquote, in. And this is what we're saying. Yes, the judge has locked the door, as it were. He did that on June the 8th of 2015. We notified as many of our members that Judge Reggie B. Walton was getting ready to, for all intents and purposes, lock the door to these lawsuits. These lawsuits, particularly the lawsuits against the USDA for racial discrimination against USDA for black farmers, Native American farmers and ranchers, Hispanic farmers and ranchers and women, was started, or that door was unlocked, on April the 14th of 1999, when the Honorable Judge Paul L. Friedman blew life, as it were, into the first lawsuit styled Timothy C. Pickford versus Dan Glickman. Dan Glickman was the Secretary of Agriculture in 1999, and in particular in 1998, in August of 1998, when the first group of black farmers filed their quote-unquote complaints. So the judge then, after Congress created legislation to allow these claimants to come into court, or in our analogy, come into the bank vault is open, the bank is doing business, the administrators, the adjudicators were doing business, filing claims, processing claims, people were meeting around the country. Now, Congress said there's going to be a time which we will terminate the tolling of the statute of limitation. We talked about that in detail in previous videos, so I won't go a lot into that. But back to the bank analogy to explain the comments and the questions that people are raising about whether the lawsuits are closed or not. Here again, BIFA, along with some other plaintiffs, while the bank was still open, moved into the bank, got into the court before Judge Walton locked the door. So yes, it is closed, but there are people still on the inside that are transacting business that is not complete. In lawsuits, they call it pending, for the most part, pending actions. One of the pending actions and claims that we have pending in court regards the last lawsuit that we filed last year, 2015, on behalf of black males. You will recall the claims administrator in Portland, Oregon, Epic Systems Incorporated, sent out letters to every person or claimant who had filed a claim on behalf of an African American male and summarily denied them, meaning they denied them without even the benefit of hearing their argument. We argued our attorneys then in turn filed a class action lawsuit against the claims administrator in Portland, Oregon, and against the Department of Agriculture, its boss, as it were, for violating a constitutional statute or right that all citizens in this country have, to include black males. We filed a motion under what is called the Civil Rights Act, or Title VI, rather, of the Civil Rights Act of 1964. Interestingly enough, when we go back to Judge Freeman's original opinion, when he certified the lawsuit in April of 1999, he said, among other things, he quoted from his opinion where he says, "Whether or not the government explicitly states in this consent decree, however, the Constitution and laws of the United States continue to forbid discrimination on the basis of race." And he cites two amendments, particularly the United States Constitutional at Amendment 5, the Fifth Amendment, and he talked about a statute that we use called the Equal Credit Opportunity Act. And more important, he cited another statute that is Title 42, United States Code, Section 2000D. And that simply means violating the Civil Rights Act, Title VI of the Civil Rights Act of 1964. So Judge Freeman said then that USDA would probably be brought back into court if it was found by advocacy associations. And that's what we are. We advocate for our members, and therefore we will sue even USDA, for violating the Constitution of our members' rights, particularly if those violations occurred during the time before the door of the lawsuits became locked.
You mentioned that BFAA is an advocacy organization. Does that mean that BFAA will be filing other lawsuits in the future?
Yes, that's an excellent question, because a lot of people think that BFA, this association, will only file claims against the USDA for racial discrimination in a credit transaction. Now, that is a credit transaction, or denying African American farmers, denying Hispanic farmers and ranchers the right to apply for credit. The right to apply for credit is a contract right. In other words, Congress, you'll hear the old saying, well, it's going to take an act of Congress. Well, Congress acted. Congress acted in 1866 when it created the Civil Rights Act for the benefit of African Americans. Most of us think that our civil rights movement started, as it were, in the 1960s. As a matter of fact, it did not. That's not to take anything away from those who participated in the marches in Montgomery and the civil rights case of Brown versus the Board of Education. Those were the 1950s and 1960s civil rights movement. However, Congress created virtually every one of the laws or statutes that the lawyers used in Brown versus the Board of Education, in Browder versus Gale, which was the case involving Miss Rosa Parks' inability to sit where she, in effect, purchased a ticket. In other words, Congress in 1866 said, among other things, 1 year after slavery, the emancipation, that it will do no good effectively if a person who is free is not allowed to enter into what? Contracts. Because in order to be able to purchase goods, in order to own land, in order to purchase cars and houses, those are contract rights. The right to credit for an individual, as I said earlier about a bank. We have the right to go into a bank and contract and apply for credit. What happened with USDA, particularly in the early 80s and 1981, that's not to say they didn't do it before. But Congress said that if a person went to USDA and tried to contract for credit, to apply for a loan, or to ask for an existing loan to be rescheduled under an act called ECOA. We talked about that one earlier, the Equal Credit Opportunity Act. And if USDA employees deny you the right to even let you apply for that application or loan, they violated the Constitution. And therefore, you can sue that person in a court of law for relief. So the Equal Credit Opportunity Act was the statute, was the tool, as it were, one of the tools that Congress created to allow minority groups and what we call individuals of a socially disadvantaged class to file a lawsuit against USDA. Now, when USDA also violated our members' right, particularly those who were filing on behalf of African Americans, they violated another statute. Or at least we argued they violated two more. They violated the right by summarily denying an African American male based on nothing but the fact that your application stated that you are an African American male, and for that reason, your claim is denied. It doesn't get any more blatant than that. That is a Title VI violation, at least BIFA believes, and our attorneys believes, squarely on its face. So in addition now to those black males having a claim against USDA for discriminating against them, trying to get a loan while they were in the bank between 81 and 1996, the claims administrator created another violation against them by saying, we're going to let Native Americans be a part of the lawsuit. We're going to let white women be a part of the lawsuit. We're going to let Hispanics be a part of the lawsuits, but we are not going to allow an African American male. That violated another statute, and for that reason, we're suing him. So as an advocacy association, that's basically what we do for our members. We believe that one of the reasons the African American community has lost so many acres of farmland from 1865 to 1910, African Americans acquired close to 20 million acres of farmland. Today, we own about 2 million acres. So after slavery, we own our ancestors who could not read, ebonically speaking, didn't know where a college or a university was at, but they own on a per capita basis more land than we do today. USDA was found guilty of denying African Americans the right to contract to make that land productive. They own the land, but now they need to, in order to make it productive, they needed money to operate. They needed the seeds, they needed the equipment. So when USDA denied them the right to contract for credit, it violated that section. And therefore, so they were discriminated against USDA at the banking level, and now they're being discriminated against because an official, a neutral, that USDA hired, i.e. the claims administrator, we believe also violated their rights. So our position is that BIFA, every time one of our members' rights violated, as a advocacy association, as a civil rights association, that's what you do. You sue. Now, the other argument would be, why are you always suing people? The question is, well, as long as someone is violating our members' rights, then there ought to be someone out there suing to stop that violation. And that's what we do, and that's what we will continue to do. More importantly, we want to make sure that our members call in or respond either by calling this office, going to our website, which is www.mybfaa.us, register, among other things, read these documents, but register your email. Tell a friend to register the email. Most people think, well, I'm not farming right now, so I might not need to be a member of BEFA. I might not be interested in the lawsuit. But we are also now starting to file claims on behalf of black families who are losing land at the local level, the state level, the 2 million acres that I talked about that we have now. Over the years, certain laws and state actors have purchased land or purchased an interest in land in the black community and then take those individuals to court in a method known as partitionment and use that method to deprive us of our ownership. So as long as our members are being, or their rights are being violated, we will be there to defend them for that violation.
Mr. Burrell, some of our members have called the BEFA office in regards to a document they've received or saw on the internet. Can you please explain what this is all about?
You're referencing a document that was filed last year, as a matter of fact, by a group known as the Minority Farm Advocacy Committee. We talked about advocacy earlier. There are other groups out there advocating for their members as well. What is interesting, though, about this document is the date that is on the document. Now, we talked about here again whether the lawsuit is closed or not. Now, as we said earlier, it may be closed, but that doesn't stop an individual from filing motions in the lawsuit. Look at the date at the top of this document. It says Case 1-00-CV 02502 RBW. That means Judge Reggie B. Walton. Its number is docket number 264. Now remember, Judge Reggie B. Walton is the judge that locked the door to the bank vault, as it were, locked the door to the lawsuit on June the 8th of 2015, right? But notice the date that this document is filed. 01/1916. That is to say, January the 19th of 2016, this year. Now, if the lawsuit were closed, as people are indicating, how was it this group was able to file a document in Judge Walton's court? Not only was the docket filed, look who filed the docket. It was filed by 2 attorneys in particular, Alexander Pires and Phil Frost. These lawyers have been around since Pickford 1. So if the lawsuit were closed, why would these lawyers then file a motion in Judge Walton's court after Judge Walton closed the lawsuit? It proves the point that we made earlier. The lawsuit may be closed, but it doesn't stop folk who are inside of the lawsuit from continuing to file motions and continuing to file complaints. This lawsuit and the date that it was filed proves our point. What this group is asking for, this group known as the Minority Farm Advocacy Committee, they are arguing on behalf of some of the thousands of individuals who were denied in the Hispanic female farmers and ranchers voluntary claims process. Remember, that lawsuit will style the Hispanic and farmers and ranchers framework. So therefore, there's another advocacy group saying, we believe our members, and so do we here at the Black Farmers, believe that our members were done wrong in this process. However, we beat them to the punch. We've already filed motions arguing that the results of that lawsuit violated the Equal Protection Clause of the Constitution, violated the Due Process Clause of the Constitution, and that a lot of members were not treated fairly in the adjudication of this lawsuit. But here again, it proves the point that you can still file lawsuits, quote unquote, after the lawsuit is closed.
Mr. Burrell, thank you so much for your time and insight. You've been very enlightening.
Well, thank you for that comment, and we hope that our members or those who are friends would be enlightened as well. We believe that this organization has a very worthwhile mission, and that is to be a defender for civil rights against unlawful violations, unconstitutional violations that have been visited upon the African American community in general and black landowners and farmers in particular. And we want our members to hear again to go to www.mybfaa.us and call 901-522-8880 for further comments and to make sure that their address and or telephone numbers are accurate. Thank you.